Good morning, everyone. Thank you very much for joining us in the latest in our series of webinars relating to all things mental capacity, deprivation of liberty, and court of protection. Firstly, some housekeeping. So everyone's cameras are automatically switched off for this webinar and your microphones will be muted. So if you have any questions, please do submit them using the Ask a Question box on your screen, and we'll respond to as many questions as we can during today's session. We've got plenty of time for questions at the end, as you'll see in a moment. Today's webinar is being recorded and you can access the recording using the audience joining link. It will also be circulated after today via an email, as will the presentation slides. So I know lots of people like to ask if they'll receive the slides afterwards. Yes, you will, but you can also download them from the screen using the presentation slides box today. Your feedback is really important to us, so I'd encourage you to take the time to complete our survey at the end of the webinar, or you can click on the orange icon at the bottom of your screen to access that survey. These webinars use a lot of bandwidth, so it's a good idea to close all your other browsers and other programs. If you have any technical issues, try pressing F5 to refresh your screen, or the old classic leaving and rejoining. Otherwise, our team will respond to questions in the Q&A. Some of the common issues, please make sure your computer speakers or headset speakers are turned on and the volume is up if you're having any difficulty with volume. So just to welcome you all again today, it is an exciting time if you're interested in the law related to mental capacity and deprivation of liberty and court of protection case law, following the government's announcement at the weekend that it would launch a consultation on liberty protection safeguards in the first half of next year, and their responses to that consultation will be used to inform a final Mental Capacity Act court of protection. Something that many of us thought would never happen, now seems to be firmly back on the agenda. I'm sure there's lots of mixed feelings in the virtual room today, perhaps some optimism for finally sorting out the difficult DoLS regime, but trepidation as to whether this is simply replacing one bureaucratic and complex system with another, and perhaps some frustration and impatience, knowing that surely liberty protection safeguards are still many years away, based on the timeline that we have at the moment. It's surely no coincidence that that announcement comes as the Supreme Court is considering the definition of deprivation of liberty over today, yesterday, and tomorrow. It's being argued in that case that the definition of deprivation of liberty goes too far, it's resource heavy, and captures too many people in ordinary care settings. So I know that we'll all be waiting the outcome of that case with bated breath. We'll keep you up to date as matters develop, and you can follow myself or one of the speakers on LinkedIn if you're not already connected with us to receive our regular updates, or if you're not already signed up to receive our updates, please take the opportunity to do that following the follow-up email that you get after today's session. On to what we're covering today. I'm joined by my colleague Rachel Kelly, who will be picking up shortly to talk to you about Section 21A applications. Secondly, my colleague Ellie Maudsley is going to give you a case law update regarding some recent and interesting cases. And Rachel Watkinson also joins us, and her talk will be about the Get Me to Hospital guidance. And as I mentioned, we do have time for questions and answers at the end of today's session. So I hope that you're going to find today's session really useful and insightful, and I'll hand over to Rachel Kelly first of all.
Thanks, Joanna. And just as an early caveat, I understand that this platform picks up background noise. If you hear a snore, don't be alarmed. It's just my dog at my feet. But hopefully you won't be entertained by that as well. So I'm speaking about Section 21A proceedings. In terms of agenda for this, what we're going to discuss is a bit of background in terms of what is a deprivation of liberty, briefly about that, some consequences of an unlawful deprivation of liberty to give you firm examples of what has happened in some previous cases. And then we're going to go through the 21A process. I can well imagine that a lot of you have been involved in 21A proceedings, and sometimes there can be some confusion around them, particularly when a placement is somewhere that's considered to be best for the individual. So hopefully we can have a bit of discussion about that and improve the understanding over them as well. So what is a deprivation of liberty? And I promise I'm just clicking through these slides. It isn't for all the slides that I have to do this. So it's fundamental, a human right to freedom under Article 5 of the European Convention. Deprivation of liberty safeguards, which is what the 21A proceedings essentially stem from, allow a person to be deprived of their liberty to keep them safe from harm if they lack capacity to consent. And I'm sure you're all aware that the acid test for this, in the case of Cheshire West, and that was how it was established. And it is based on whether the person is subject to continuous supervision and control. Is the person free to leave? Do they have capacity to consent? And if, as the answers portray in the slide, if the answer is yes, no, and no, then it's more highly likely that a deprivation of liberty arises or is arising and authorization is sought by way of one of the routes. If someone is subject to a high level of supervision and is not free to leave the premises permanently, it's almost certain that they are deprived of their liberty, and one of the appropriate procedures has to be followed to authorize that deprivation of liberty, depending on the setting that they're in. And today, as I said, we're focusing from my perspective on care homes and hospitals, which is what 21A proceedings come out of. This is because it's the standard authorization that has to be put in to authorize that deprivation of liberty. And usually what happens is the managing authority, which is the hospital or a care home, puts in a request for a standard authorization from the supervisory body, which is usually the local authority. And then a number of assessments are completed to establish if it is in the individual's best interest to be deprived of their liberty at that location. And those assessments include age, mental health, mental capacity, best interests, eligibility, and no refusal. Now, what I mean by each of those is, in order for a standard authorization to be applicable, the age has to be 18 or over, and a nod here to LPS as that was to see a change in that age limit, but we'll see what happens with that. In terms of mental health, it's confirming a diagnosed mental disorder. Mental capacity is confirming that an individual lacks capacity to make decisions about care. Best interest is determining if the deprivation of liberty is necessary and proportionate and in the best interest in order to keep them safe and to provide them with the care that they are assessed as needing. Eligibility is determining if the person meets the other criteria for a deprivation of liberty. Sometimes there are circumstances which make an individual ineligible. For example, if they are able to be detained under the Mental Health Act. And the no refusals means ensuring that the individual has not made a valid advance decision to refuse care, and equally is not refusing the care and treatment and care they're receiving at the placement and wanting to leave that placement. Now, the standard authorization should be reviewed regularly, and it can last up to 12 months. It can also come with additional conditions that are attached to minimize restrictions. For example, some of the conditions I've seen is that they'd have regular access to the community, or they should be reviewed by psychology or a service. So they can come with those conditions that it's all maintained and kept in check and review to ensure that this is actually in the person's best interest to be deprived of their liberty. Now, I mentioned in the agenda that we talk about briefly some of the consequences of an unlawful deprivation of liberty. And if someone is deprived unlawfully, meaning without authority, then the public body who is depriving them of their liberty will be acting unlawfully. On the screen, you'll see some examples of some cases where costs have been awarded due to a breach of the individual's human rights. So Hillingdon v Neary was 1 year of unlawful detention, £35,000 in damages. LA v Mr. and Mrs. D, 4 months unlawful detention, was 15,000 and 12,500 respectively, and Essex County Council VRF was 13 months unlawful detention, and that was £60,000. And ultimately, there is two types of breaches: a procedural breach and a substantive breach. A procedural breach, which is largely the most common, actually, is where seeking the authorization for the deprivation of liberty would have made no difference to the individual's living or care arrangements, so they would still have been detained. In those cases, which differ to the ones on the screen, it's usually nominal damages that are awarded, which can be, as I say, nominal, so very low. But the concern here more so is legal costs, because even if the damages are nominal, if they're awarded that their legal costs are paid, they can be significant. So it's still something to be very much aware of. Substantive breaches, on the other hand, these occur where if the public body had acted lawfully, the individual would not have been detained. So those breaches have more serious consequences for the individual, and therefore they have greater damages awarded, as we see up on the screen. And it can be tricky to determine between the two, and it's not always, you're not always able to know for sure until it's properly reviewed. So getting to the crux of Section 21A in itself, this arises where if the individual wants to challenge their deprivation of liberty in a care home. Now, this can be, in the two most common types, is that the individual is in a care home and they don't wish to be there, or they want to move to a different placement. Largely we'll see a lot of individuals who may want to return home, but ultimately that's not an option. It does not matter in essence that it's not an option. It matters that the individual is objecting. And if they are objecting, they have the right for this to be reviewed through Section 21A proceedings. I'll go into this in a bit more detail in terms of the procedure of these cases, but it is often the case that someone's in the right placement, it's successfully meeting their needs, there's no alternative options, i.e. they can't return home, but it has to be reviewed and considered carefully and explained why the current placement is the right setting for them. And that's the whole purpose of those 21A proceedings, that it is still appropriate and in the best interest for that deprivation of liberty to be authorised. Now, the second type is usually where an individual is not in the right placement, or it's not the least restrictive. And again, it's important in these cases for a full and thorough review to be done, and searches have to be completed with a best interests analysis, which I'll go into a bit more detail in shortly. And the court has to be updated, and parties have to be updated as to what is being done to look for a more appropriate placement for this individual. And here, just a brief case study, and I imagine an awful lot of you see this all the time. So there is, in this case, John, a gentleman with dementia and mobility problems. He's residing in a care home and is subject to a standard authorisation. He started saying that he wants to return home. His deprivation of liberty can therefore be challenged using Section 21A proceedings. Now, the individual, in this case, John, has automatic access to non-means tested legal aid in this circumstance, and usually applications are brought by the individual on their behalf with assistance from the relevant personal representative that is set out in the standard authorization, or an independent mental capacity advocate. So it is usually brought on their behalf. Ultimately, if P is objecting and, for example, they may be in a hospital, if they're not bringing it themselves, it is usually the local authority as the supervisory body that does so, and that is generally how the cases commence. So in terms of, in terms of the applications, so the application will be made if whoever is the commissioner of the care will be a party to the proceedings. Usually then, in addition to that, it is the individual themselves by way of a litigation friend. It will usually be the supervisory body, the local authority who's authorised the deprivation of liberty, and any other actors who are involved. It can be family members. Oftentimes we'll see that it may be that family members dispute the placement, so they can also be parties to the proceedings as well. And it's very important at the outset of these proceedings that we start to get the evidence together early and comprehensively. So if we can obtain records and get evidence together that we've so for example, if someone is continuing healthcare funded, if we can have the DST, documents like that are really helpful to speed up the initial process of understanding what the individual's needs are, and then they limit the need for further evidence down the line if that's already established at the outset. Now, in terms of a witness statement, examples on the screen of what it should really include and what it needs to run through in terms of your evidence. It's very important to be thorough when identifying placement options and chasing placement options regularly to give the outcome of what they've said, and to ensure all possible options are being explored, and distinguishing between what is available and not in someone's best interest versus what's not available or won't be commissioned by the public body, because they're two very different things. Sometimes it can feel like it's a burden and unnecessary to go through these if something isn't an available option, but ultimately what you are required to do is set out your consideration as in the most thorough way possible, and if something is an available option, you have to justify why it isn't an available option, and then it can be properly discounted. So it is insufficient to not include something if it's not available. It always has to come with an explanation, and the more comprehensive you are in a witness statement, the less likely it is to lead to further evidence down the line being needed, and in addition to oral evidence being needed at a final hearing as well. And it's important that within those witness statements there is a careful consideration as to best interests, and we've set out a bit of a balance sheet analysis here as an example. And those types of balance sheets really show that consideration has been given to each placement and why, and the myriad of reasons why something may be possible for a person or may not be possible for a person, but it really shows your analysis and thinking, and that's what the court wants to see. And you're less likely, as I've said, to have questions if that's covered in a thorough way. Now, in terms of moving further into the proceedings, once the evidence is coming from the commissioner, it's then likely that we'll receive evidence from the family if they're involved. There'll then be the individual's wishes and feelings, as to the extent that they're able to be obtained, will be submitted in evidence. And then usually there's a round table meeting that all the parties attend in order to hopefully narrow the issues for the court to determine. And a lot of the time, agreement can be reached. And there may be many hearings throughout the proceedings if they're required, if there's any dispute or if further evidence needs to be set out, or a lot of the time this can be dealt with on the papers, or agreement can be reached as to if there's any further evidence that's needed. And as I've touched on, a lot of the time the agreement can be reached in these proceedings, but in order to limit or avoid court proceedings, it's important that reviews are done at regular intervals, as they are supposed to be. Consider the individual's views when they're being placed, and do those thorough assessments of the care plan and restrictions on a regular basis. And also it's about considering whether all restrictions are necessary, or whether any can be reviewed. Sometimes 21A applications are made not even because the individual wants to move, but because they want more access to the community, visits to family, or access to things like the internet. Any restrictions that are in place must be deemed necessary and proportionate. And as I said, it should always be kept under review. And for example, a prime example of this is a person may move into a care home and initially be under a period of 2-to-1 or 1-to-1 whilst the care home gets used to their needs. That might be able to be stepped down once an individual is settled in. So it's about keeping that under review and making sure that the restrictions that are in place are necessary and proportionate. And in terms of making the core process easier internally for you as commissioners, it's about allocating protected time to the appropriate person who's dealing with this, so they have the proper time to provide the evidence and thoroughly consider and review the options. Ensuring that you are aware of the funding arrangements. Is this CHC? Is it 117 aftercare, or is it a joint package of care, and what's the split? Is there an arrangement in place for a certain public body to take the lead? Also have a good understanding of the individual situation, any objections that they have and their care needs. Check when the most recent reviews were carried out. If not done recently, do they need to be done? Has anything triggered a review, and does that need to be redone? And looking at alternative options, being certain that in your analysis that this is the best place for this individual and that you have the reasons for that. Consider if there's issues about community access, whether you're prepared to commission additional support for this individual, and generally having that thorough witness evidence and good communication with the solicitor once we're in proceedings to try and limit and make this as smooth as possible a process. If you can evidence at the outset that all of this has been done and is being done, then it really limits and takes the bite out of the proceedings, and it will make it a much easier process for all that are involved. They still have to be brought if a person's objecting, but it limits the time within the court process if all of this evidence is available and done at the outset. So I'll now hand over to my colleague Ellie Maudsley, who's going to provide a case law update.
Thanks, Rachel. So I'm just going to talk through a few recent cases that we've seen be reported on through the most recent ones that we found quite interesting. The first one is Blackpool Teaching Hospitals NHS Foundation Trust versus GWS and others. This case concerned a finely balanced capacity assessment and re-emphasised the law in relation to capacity. GWS was 18 and he was diagnosed with a very small capacity bladder, and he had undergone a bilateral stent insertion. The court in the case heard of GWS's difficult and traumatic childhood and his use of drugs, mainly ketamine, since the age of 12. GWS was admitted to hospital and the recommended treatment was for surgery to replace the stents because there was risk of loss of one or both kidneys, sepsis, or even death. GWS declined to have this treatment as an inpatient, but he said he would consider having it as an outpatient once he had been discharged. A number of capacity assessments were completed by a number of different professionals, and they reached different conclusions. Some of them concluded that GWS had capacity, and others concluded he lacked capacity. The parties and the court decided to instruct a joint expert, Dr. Glover. Dr. Glover initially concluded that GWS had capacity to make the decision. In Dr. Glover's oral evidence, he confirmed that the decision he focused on when assessing GWS was related to nutrition and antibiotics, but later he referred to stent replacement and discharge from hospital. He considered that GWS's decision to be treated for the stent replacement as an outpatient was silly but not disordered. In an addendum report, Dr. Glover's opinion did change slightly because he believed, having more evidence, that there was stronger evidence of GWS's PTSD and that the ongoing symptoms influenced his misuse of substances. He therefore considered that the decision was more finely balanced, but he did continue to believe by a fine margin that GWS had capacity. The Trust, local authority and the ICB, who were parties in the case, supported the position that GWS's underlying impairments, compounded by his present circumstances, were preventing him from using and weighing up the information relevant to decisions about treatment and discharge. The official solicitor invited the court to conclude that GWS's decisions about the proposed treatment do not show an inability to use and weigh information or make a decision. The judge acknowledged that a capacitous individual might make a decision in the face of advice where the outcome is catastrophic, but he decided on the balance of probabilities that GWS was not able to use and weigh the information in the decision, and that the reason for this inability was the considerable evidence that GWS was suffering from multiple impairments of his mind and brain within the meaning of Section 2, subsection 1 of the Mental Capacity Act. Namely, these were a confirmed diagnosis of ADHD, clear evidence of PTSD, an ongoing dependency syndrome in relation to ketamine, and also possibly elements of autism. However, he didn't have a formal diagnosis of this. The judge concluded in this case that GWS does not currently have capacity to make decisions about his treatment, to discharge himself from hospital prior to that surgery being undertaken, or to conduct litigation. The next case is Patricia's father and others versus Patricia and others. This sad case considered balancing autonomy and the preservation of life. The matter relates to Patricia, who is a 25-year-old who suffered with anorexia nervosa and pathological demand avoidance from the age of 10. Despite her will to live, she refuses to consume the requisite calories that she requires, which resulted in her requiring a Zimmer frame to mobilise and admission to specialist eating disorder units. Patricia's case was first considered back in May 2023 due to her being critically ill with liver failure and considered to be in a pre-death phase. The trust involved recommended nasogastric feeding under restraint. Patricia opposed the forced treatment and described past experiences as torture. The judge found that Patricia lacked capacity to make treatment decisions, but it was not in her best interest to be force-fed under restraint. The judge stressed the importance of autonomy and considered force-feeding likely futile and distressing. The matter returned before the same judge in October 2023 as Patricia's condition had deteriorated further and she wished to go to a specialist eating disorder unit but was medically unstable. The judge extended the May 2023 order to cover all hospital admissions and stated that Patricia should not receive medical treatment against her wishes. Fast forward to March 2025 and an urgent application was made by Patricia's family because they feared that she would be discharged to palliative care as her condition worsened. An interim injunction was issued to prevent discharge, but Patricia's family also sought to lift the orders made back in 2023, believing that without intervention, Patricia was at imminent risk of death. Patricia strongly opposed the application, citing trauma and PTSD and arguing that autonomy was essential for her to engage with treatment. The judge in 2025 found that the court had jurisdiction to revisit the 2023 orders. She found that Patricia lacked capacity to make treatment decisions and that the 2023 orders placed an impossible burden on her, and Patricia's condition had deteriorated. Lifting those orders would allow clinicians to consider all treatment options under the Mental Health Act, and the balance of harm versus the benefit favoured lifting the orders to preserve life. The court concluded that it was in Patricia's best interest to lift those orders that were made in 2023. This decision doesn't mandate force feeding, but it removed the legal barriers to treatment decisions by clinicians. The judge emphasised that trust should still consider the decision from Nottinghamshire Healthcare NHS Trust and RC, which recommended that where the approved clinician decides not to impose treatment under Section 63 of the Mental Health Act and the consequences may be life-threatening, the NHS Trust should apply to the High Court for declaratory relief. However, Patricia's case reinforces the need to keep such decisions under ongoing review. In the case of Hillingdon Hospital's NHS Foundation Trust versus YD, this highlighted the importance of the holistic assessment of best interests. YD is a 60-year-old man who is in a persistent disorder of consciousness following having a bleed in his brain in 2024. The medical evidence in this case was unanimous in considering that it was not in YD's best interest to continue to receive clinically assisted nutrition and hydration. However, both of his partners considered that YD would want to continue to receive such treatment and cared for him each day alongside hospital staff. His partners hadn't known of each other's existence for over more than 20 years prior to YD being admitted to hospital, but they both had the same view as to what YD would have wanted. This view was also supported by a close friend of YD who's known him for over 20 years, whose views were also obtained in the proceedings. The application brought by the Trust was opposed by YD's partners and the official solicitor. On YD's behalf, the official solicitor's submissions were that each of his partners and his close friend were clear in their view that YD would have wished to have his physical existence maintained by clinically assisted nutrition and hydration, and would have wanted the continued opportunity to heal himself, and that his present feeling would be that his life is now dignified because of the love and care provided to him by his partners, and he would wish to continue in this way until the life of his body was ended by a process such as a heart attack, a further stroke, or an infection. In declining the trust application and not considering the burdens to outweigh the benefits of ongoing provision of clinically assisted nutrition and hydration, the judge stated that it was striking that even though they had known, his partners had each known YD for 20 and 24 years respectively, they had not known each other prior to October 2024, and they were unaware of each other's existence. Yet despite that separation over such an extended period of time, they were each able to independently confirm many common features about YD's wishes and beliefs. So this judgment just provides a further reminder of the need for a holistic approach to be taken to best interests considerations. In this sad case of Rejay, the High Court was asked to consider withdrawal of mechanical ventilation from a 20-day-old baby. The baby's mother had sadly suffered a cardiac arrest after a choking incident and cocaine use, and as a result of this, she suffered hypoxic brain damage and spent 40 minutes without a heartbeat. Baby J was born by emergency C-section at 32 weeks of gestational age. And as a result of this, he had severe hypoxic ischemic encephalopathy. Due to her own injuries, Baby J's mother didn't have capacity to consent or refuse treatment on his behalf, specifically in regards to withdrawal of mechanical ventilation. The Trust considered that it was overly burdensome and unethical to continue to provide ventilation to Baby J. He had a catastrophic brain injury with no realistic prospect of recovery. The continuation of intensive care and ventilation would prolong his suffering, and it was accepted that Baby J felt pain as he needed to be treated with morphine. Initially in the case, the child's guardian had asked for an adjournment for 2 weeks to see if his mother could regain capacity sufficiently to make a decision on his behalf. However, the judge felt that that was too long and unfair on Baby J due to his suffering. A shorter adjournment was allowed to gather further evidence. Baby J's wider family were contacted and were in support of the application, with his great-grandmother commenting that it would be disaster to let him go on. The judge carefully weighed Baby J's best interest in the balance, observing that there is a strong presumption in favour of taking all steps to preserve life because the individual human instinct to survive is strong and must be presumed to be strong in the patient. The presumption, however, is not irrebuttable. It may be outweighed if the pleasures and the quality of life are sufficiently small and the pain and suffering and other burdens are sufficiently great. So ultimately, in this case, the judge determined that continued mechanical ventilation was a burden to Baby J. He understood why the clinicians considered that it was unethical and ruled that continued mechanical ventilation and intensive care was no longer in his best interests. The final case that we're going to look at is Ree Gardner. In this case, these proceedings related to an advanced decision to refuse treatment. Mr. Gardner suffered a brain injury following a heart attack and suffered with a prolonged disorder of consciousness. He was receiving clinically assisted nutrition and hydration to keep him alive, and he had signed a living will which stated that he would refuse such treatment. There was, however, concern amongst his family about the validity of that document, and family were concerned that Mr. Gardner's fiancée was attempting to restrict their access to see him. After reviewing the medical evidence and the advanced decision to refuse treatment itself, the judge concluded that it was valid and applicable, and following a final hearing in June 2025, the judge made an order on the 4th of July directing Mr. Gardner's transfer to a hospice for palliative care in accordance with the choices he had made in his advanced decision to refuse treatment. Mr. Gardner sadly died a few days after his discharge. There was, however, a further issue in this case relating to the transparency order in place. The order of the 4th of July that the judge made also included a direction that the transparency order in place in the proceedings would cease to have effect from the 30th of August. This was made on the basis that Mr. Gardner was likely to die within a short time following the transfer to hospice, and that the transparency order was to be discharged after a suitable cooling off period following his death. Members of Mr. Gardner's family made an application to extend the transparency order beyond the 30th of August to protect their privacy after the proceedings had concluded. The judge considered this and noted that the transparency order was in the standard form, apart from him adding to the protected information some details about Mr. Gardner's personal life. The judge observed that whilst the transparency order is an injunction, it isn't against the world, but applies widely not only to the parties and their representatives, but also to witnesses, all persons who attend a hearing, all persons who by any means obtain or are given an account or record of a hearing, or who obtain documents and information arising from the application, and any body or organisation and their employees and agents for whom any such person works or is giving evidence. The parties all agreed that the proceedings relating to Mr. Gardner raised issues of substantial public interest in relation to the issue of the authenticity of the advance decision to refuse treatment and the potential for allegations of fraud to be made in such cases. On behalf of the family, it was submitted that the issues could be fully aired and debated without naming Mr. Gardner or members of the family, and that continuation of the transparency order would not materially affect the Article 8 rights of others, whereas the family's Article 10 rights of others, whereas the family's Article 8 rights would be significantly interfered with should the transparency order be discharged. On behalf of Mr. Gardner's fiancée, it was felt that the transparency order suppressed her freedom of speech. The judge expressed doubts that the purpose of a standard transparency order is to protect Article 8 rights of anyone other than the person, so in this case, Mr. Gardner. The inclusion of family members within the protected information is designed to avoid jigsaw identification. The judge noted that the application made by the family was in essence a new application to use the transparency order to protect their privacy after the conclusion of proceedings. So they had not applied for a fresh transparency order, but rather sought to extend the current one. In the majority of cases made in the Court of Protection, proceedings ought to be discharged upon the person's death or shortly after. The purpose of the transparency order is to protect the anonymity of the person during proceedings and their life. The judge considered the competing Article 8 and Article 10 rights and noted that the continuation of the transparency order would significantly restrict the freedom of expression of Mr. Gardner's fiancée and others, and there is a strong public interest in them being free to comment on this case. The judge was unable to identify any countervailing interference with the Article 8 rights of the members of the family sufficient to justify the continuation of the restrictions on the Article 10 right, and as such, the judge refused the family's application and discharged the transparency order. I'll now pass you over to Rachel Watkinson, who will talk through the Get Me to Hospital guidance.
Morning, everybody. Sorry, I'm just getting my slides up. Here we go. Apologies for that. So this guidance isn't establishing any new legal principles. It's essentially just trying to pull together pointers and resources to try to support practitioners and families to be able to ensure as far as possible that individuals with disabilities receive equitable access to healthcare. So it was produced by the Social Care Institute for Excellence, but it also had input from the Stop People Dying Too Young group, the National Mental Capacity Forum, and also some prominent legal advisors in this practice area. It also aligns itself with NHS England's national guidance published in order to support implementation of the MCA in acute trusts for adults with learning disabilities. So it sort of follows on from that, but maybe is the starting point of actually getting those individuals safely into hospital. So just for a bit of context, the Learning from Lives and Deaths annual report in 2022 found the median age for death for people with learning disability was around 62.9 years. And they reported top causes being cancer, flu and heart disease. So a lot of those are treatable treatable and in some cases preventable conditions. What was also found that in addition to that, if an individual also identified as mixed ethnicity, Asian, Black, Caribbean or African, it increased that likelihood of dying earlier by a huge 190%. So these are significant figures. And then just for context, the Office for National Statistics places the average life expectancy in the UK between 2020 and 2022 at 78.6 years for males and 82.6 years for females. So there is quite a significant disparity in life expectancy for individuals more generally when compared with those with disabilities. And so the aim of this guidance is to just avoid those scenarios where maybe individuals aren't brought into hospital or at all, or aren't brought into hospital maybe as quickly as they should be because of difficulties in actually getting the person to agree to come into the hospital and those arrangements in place. So what the guidance is trying to do is promote proper consideration of an individual's capacity to make that decision around hospital admission, particularly where there's a refusal. So although there is a presumption in favour of capacity, just being very careful about not trying to rely on that where there's clear evidence that the person may not fully understand that decision or the consequences of that decision. So all of the relevant information around why the hospital admission is needed, what the purpose is, and what the risks, what the benefits might be and what the risks might be if they don't do that. So there is case law that talks about this and explains obviously why the presumption of capacity is important, and it ensures proper respect for personal autonomy by requiring a decision as to a lack of capacity to be based on evidence. The presumption, like anything else, has logical limits. So where there is a good reason for concern and there's a legitimate doubt as to capacity to make the relevant decision, the presumption cannot be used to avoid taking responsibility for assessing and determining capacity. To do so would fail to respect personal autonomy in a different way. So there is clear case law around the importance of this being done. So it's really important for anyone who's involved in supporting individuals, whether they are community-based, actually supporting individuals in care homes, in care packages, ambulance services, and also liaison between community services and hospitals to arrange the admission. It's really important that everyone is aware and alive to those difficulties. The aim is to make sure that individuals who have additional needs for support, so might need additional time to understand information, additional resources around communication, additional support, to make sure they still can get access to appropriate healthcare. A lot of the time, these individuals might not be able to accurately communicate any symptoms or issues that they have. And so it's really aimed at ensuring that everyone is alive to those issues and making sure that those individuals are properly supported when they need to come into hospital. So a key point of the guidance is trying to advance plan for an emergency situation. So obviously you can't always pinpoint when an emergency situation is going to happen. But I suppose what the guidance is saying is if you do have an individual who doesn't like to go to hospital, doesn't really like to engage in those types of discussions, but is, like I suppose anybody, going to be at risk at some point of needing an emergency admission to hospital. It's always really good to have a plan written down in advance that everyone can follow to say, right, in this scenario, what do we do? How do we get this person to receive the support that they need? A lot of the time that can help people to think about things that might help the person to engage in that process so that you can be less restrictive in those arrangements. But also there's something to be said about having key points of contact so that in that scenario when everyone's sort of maybe a bit flustered, panicked, that there's no delay or no unreasonable delay in getting that individual from where they are to the point where they need to be to receive the care that they need. So all the guidance is asking for is taking the time to explore those issues, taking time to explore the reasons maybe in advance that the person's reluctant. Have they had a negative experience before? Are they worried about something in particular? Is there anything that actually could be done in advance to do some work with that individual to make them feel safer about going to hospital? Doing desensitisation work with the individual, introducing them to that environment in a more positive way, and just trying to look at getting to the bottom of what the issue is in advance, because obviously you're not going to have time to do that in an emergency situation. You're just going to have to react. So I think obviously there's going to be the emergency situation that you need to deal with, but this guidance is saying, if you know that's probably a risk that is likely to happen at some point, why not try to advance plan for that? The key message, though, in all of this is, where you're faced with a situation where an individual needs to go to hospital, yes, there are legal considerations, there are issues around deprivation of liberty that might arise, but your key focus is preserving life, and that must be the priority. So it's trying to get that key message across. If you think life is at risk, you need to do what you need to do to get that person into hospital and get them the treatment that they need. So, as I mentioned before, things that you could look at doing is desensitisation work. So slowly introducing the person to the thing that they're worried about, so that you can give them the reassurance that it's something that's maybe not so scary. And there's lots of different resources within the guidance that talks about, videos that you can show the individual on YouTube of what the hospital journey might look like, maybe looking at visiting the hospital, not for an appointment as such, but just going to have a look around the hospital if that's something that the person's worried about. Often hospitals have, Costa coffee, or they have like a little shop, and maybe you could take the individual there to look at these things, to sort of get them a bit familiar with their environment and make it feel a little bit less scary for them. Maybe they have something that the person likes at the hospital that you could encourage them to say, oh, we could go there, we could have this thing that you like. And so it's just asking for some thoughtfulness around how that could be made easier. Obviously, there's a legal requirement under the Equality Act to make reasonable adjustments to ensure that an individual who has a disability can access health and care services. And so thinking about those reasonable adjustments that you can make is really important. So calling ahead in an emergency situation where you've got someone coming in for even an emergency admission, while you're asking for that communication to happen, to say, this individual's coming in, they've got this diagnosis, they've got these additional needs. Can you, there might be certain arrangements that can be made on arrival at the hospital to make that journey easier. Maybe, being taken to a quieter area within, an accident and emergency department. Whilst they are, of course, limited, there are a lot of accident and emergency departments that do have specialised places within the area that are a little bit quieter, maybe a little bit more of a more appropriate environment for individuals with additional needs, and maybe they could look at different routes of getting into the hospital and things like that. So just having those conversations is really helpful, and then looking at things like digital flags that can be put on the patient's records to say, so the hospital's aware on arrival that this is an individual who's got additional needs. Basically, contingency planning for various scenarios is what is recommended. There's also going to be the issue of your planned versus emergency admissions. If you're talking about really significant difficulties in getting an individual into hospital, where you're talking about significant restraints, maybe 4 or 5 to 1, it's going to be quite a significant journey. Maybe having to use chemical sedation, which carries additional risks. If that is something that is a real likelihood of happening, there can be consideration for prior authorisation and being sought for the court around that. It would typically have to be a realistic prospect. So this is something that you're planning for that is very likely to happen, rather than just a theoretical issue, before it would be justified to make an application to the court, in my view. But that is what is sort of suggested as a point of consideration within the guidance. So the key thing that the guidance is trying to get across is just if someone is a bit reluctant, that shouldn't be an absolute barrier to getting that person into hospital. So it doesn't mean the transfer can't take place. Where you've got someone who you think lacks capacity to make that decision for themselves, make sure that a capacity assessment is done. Obviously, in an emergency situation, it isn't going to be war and peace. It's not going to be, a really detailed, lengthy assessment. The best evidence that you can get around capacity is what is needed, so you can support that reasonable belief that you have that the person lacks capacity. And then a best interests analysis, again, usually in this scenario where you've got someone who's really unwell, needs to come to hospital, it can be quite straightforward. You do have to acknowledge the reluctance and the, any negative impacts that might come from the process of bringing the person into hospital who is objecting in that way. But it should be quite straightforward to sort of look at what's the pros, what we're trying to achieve here. When you're tipping the balance into this person will die unless they come into hospital, that's a pretty high threshold to overcome by, a reference to any negative impact that, maybe some transient restraint might have on the individual. So everyone just needs to be very realistic around what will happen if we don't get this person to hospital and what will happen in order to get this person to hospital. And it's sort of a question of which one is worse. So obviously if the risks are higher in not getting the person into hospital, notwithstanding the restraint and things that you might need to use, that would indicate that you're going to be finding that it's in the person's best interest to go into hospital. Now, the difficulty can always be in this scenario, who is the decision maker around this? So often it's going to be the ambulance crew. Sometimes it can be the GP, because the GP is saying this, making the medical recommendation to go into hospital. But a lot of the time, it actually just needs to be a joint discussion as well between, the individuals recommending the admission, the ambulance crew who are needing to transport the person, and potentially the individual and their family and the hospital receiving them, just to make sure that everyone is aware of the scenario. But ultimately, the decision around whether to take the person in the ambulance would be down to the ambulance crew. It's also flagging the importance to check whether there's any relevant lasting power of attorney in place. So is there a health and welfare LPA in place? Are there attorneys that would actually be the decision maker in terms of that decision? So they would take over that decision making where the person lacks capacity and be able to give consent to the admission. It's also important to look at, is there any advanced decision in place to refuse life-saving treatment? So if you're trying to take the patient into hospital for life-saving treatment that they've refused, obviously that's a really relevant consideration into the sort of the purpose of taking the person into hospital. So you need to be really clear around that. There are within that issues around, well, what if there's someone with a lasting power of attorney in place and the attorney is saying no to the hospital admission, and actually all the professionals really disagree with that and they don't think that the person's acting in the best interests. That is not an absolute barrier. There is provision in Section 4B of the Mental Capacity Act that says if this is life-sustaining treatment, then you can give life-sustaining treatment for anything that will prevent a serious deterioration in the person's health whilst you're making applications to the court to challenge that. So whilst you can initially, still bring the person into hospital under Section 4B, it's really important that you don't miss that next step of whilst you're making an application to the court. So that's in recognition that sometimes you're not going to have time to get that application to court to have it dealt with in time to give the emergency treatment to the individual where there's a dispute. But that dispute just needs to come to the attention of the court as soon as possible after that initial stage. So that's just something to bear in mind. So then there's this issue over when can you use restraint? When does restraint turn into deprivation of liberty? When do we need court authorisation for transfers? And when can we rely on the MCA in of itself? So if we go back to basics, Section 5 and Section 6 of the MCA can be relied on to take someone into hospital so they can receive care and treatment. So your Section 5 is, as long as you've got a reasonable belief that the person lacks capacity to make the decision and a reasonable belief that it's in the best interest to do what it is that you're proposing to do, then you're protected from liability for making that decision on behalf of the person. So that covers the decision. Section 6 puts some limitations on that in the sense of it says, well, actually, if in making that decision or facilitating that decision, putting that into place, you're going to need to use physical restraint. But you also need to justify that by saying, is it proportionate when you look at what the risk would be if you didn't use restraint? So if you didn't use restraint to get the person into hospital, what would the consequences of that be? What would the risk be to the person? How serious would that be? How likely would it be to happen? And then you work out, is it proportionate when you look at what type of restraint you're using, how long you're going to be using it for, and any impact that it would have on the person. So it's that balanced exercise. So you just have to document that proportionality decision that you've made around that. So if you're using safe holds, minimal transient restraint, guiding, etc., that is not going to be considered sufficient enough to be warranting an application to the court to support that transfer into hospital. So what the guidance says is that it's possible that restraint might last for sufficiently long that it constitutes deprivation of liberty. An ambulance journey might possibly constitute deprivation of liberty if it's a very long journey, involves very high levels of restraint. Concern about whether there will be a deprivation of liberty shouldn't prevent the person from being taken to hospital if their life is at risk. In such a situation, the need to preserve life is likely to prevail over any issue about deprivation of liberty. So I suppose what the guidance is saying is there are protections there anyway under Sections 5 and 6. And if you are a bit concerned around deprivation of liberty, that is relevant if you've got a non-urgent situation. You might need to consider authorisation in that scenario. But when you've got someone whose life is at immediate risk, it's likely that saving life is going to prevail over any concerns around whether you deprive the person of the liberty whilst you're taking them to hospital. Now, obviously I'm going to say this because I'm a lawyer, but the key is documentation. So it's really important that even, as brief as you're able to do in that scenario, you document why it was so serious, the capacity, best interest, and the proportionality in respect of why those actions are taken. It's going to be really helpful just in case any issues do arise after the event. So what the guidance is, just reiterating, which is a point that's well known. It's a point that runs through the Mental Capacity Act and any codes of practice and guidance. Restraint should be used as a last resort and always carried out in a least restrictive way. And importantly, should only be utilised by those who are trained to do that. Where there is a decision to admit, and that involves multi-agency working, then actually a mini MDT might be helpful to have sort of everyone on a call, maybe, if, depending on the urgency of the situation, to agree and coordinate any transfer. So that is making sure everyone's on the same page, making sure as smooth as possible a transition from wherever the person's going into the hospital. So everyone's really clear on who's doing what, where and when, and that should hopefully ensure a safe and effective transfer for the individual. So things that could identify is, does the person already have support staff who they know? Could they be able to be utilised to support the individual in that journey from wherever, home, placement, wherever they are, into the hospital environment? Is that going to be the least restrictive? Because these are individuals the person already knows, used to being supported by, know how to support the person, know how to use safe restraint with the person, all of those things. Is everyone really clear around who's going to be doing what? If sedation is needed, is that appropriate? Is that safe? Is everyone in a position to ensure that that can happen? That is very rare in my experience, that sedation would ever be used for a hospital transfer due to the risks. But if a scenario does arise where that is being considered, making sure that the person can be kept as safe as possible and all of those requirements are in place is going to be really important. And as I say, the difference between whether that might point to a court application or not, a lot of the time will rest on the urgency of the situation that you're facing. So in the guidance, it suggested that there are some ongoing limitations that they identified through discussions with stakeholders. And they found that there was some resistance from ambulance teams, not being able to use restraint. So I suppose that would cause a difficulty in scenarios where you've got an individual who doesn't have their own support package, or individuals care package already in place with individuals who can use that restraint. How is that going to be coordinated? Who would be able to support the patients in that scenario? I feel that may differ from area to area. I have seen cases where ambulance crews have used transient safe holds, obviously not more significant restraints, but are able to use those low-level holds. They found police will not attend for the purpose of addressing physical healthcare needs. Again, I think for individuals with additional difficulties, that's not necessarily a bad thing, and it isn't something that would be the go-to suggestion anyway, because that could cause additional distress. So I think obviously only as a last resort would it be typical to look at involving the police anyway, despite the suggestion that they really reluctant to engage in any event. And again, as we mentioned before, chemical restraint is likely to require input of a critical care paramedic. Again, my experience is that's very rare, that's suggested as an option due to the risks involved, but it is something that might need to be considered in very rare cases, which is something to be aware of. Now, helpfully in the guidance, they provide helpful links to additional resources that can support implementation of the recommendations. So things like 39I6 capacity guidance and other organisations that have produced materials that would support that. They've also got a link to an information rights leaflet, an easy read version that can be shared with individuals so that they can have information around what their rights are in terms of hospital treatment and admissions. There's also some recommendations and links to, I mentioned before, a video that sort of introduces, a typical journey through the hospital. But there's also some materials referenced within the guidance to help to support effective communication, particularly for those with maybe learning difficulties or autism. So it's got some really helpful things in there. Obviously, ultimately, it will say in any scenario that you're unsure of, seek legal advice, and it isn't replacing, legislation or statutory guidance or anything of that nature. But it is helpful, I think, to just give that indication that, in these types of scenarios where individuals need to come into hospital, just because someone is a bit reluctant doesn't mean that the question of admission should stop there and that should be pressed further. So just as an example, I had a case recently with an individual who had a suspected fracture. They weren't very keen on hospital, had been declining admission and transfer for quite a few days. And so the team around the individual, which involved the hospital, the ICB, and the supported placement that the individual was living in, worked really closely together to try and support the individual with all of his favourite things, to encourage him to come to the hospital. And actually, it was really successful in the end. He did have a fracture and he was able to be treated. And actually, turned out that he really liked it in the hospital, and was given lots of nice things while he was there, and actually made it a really positive experience. I'm not saying everything is that easy. There are other cases where things are very difficult, but taking the time to have those discussions and work with an individual can often really help. So just some things to sort of highlight around that is that there aren't any specific cases that sort of contradict the Code of Practice for the Deprivation of Liberty Safeguards, unlike where Cheshire West overrides a lot of the guidance in respect of what is the deprivation of liberty in the context of transfer, either between placements or to hospital. So there is one case back in 2009, DCC versus KH, and whilst that looked at or conveyance in the context of a care home resident attending contact sessions involving quite a long journey, involving some safe holds and transient restraint. In that case, the judge said because there was a DoLS standard authorisation, that was sufficient to be able to return P on the long journey from contact sessions back to the residential accommodation, and then found it was inappropriate to seek anticipatory declarations for the use of force, as sections 5 and 6 permitted the restraint. So that case considered those issues and felt that where that transient restraint is being used, sections 5 and 6 were all you needed to authorise that. So as I mentioned before, the Deprivation of Liberty Safeguards Code of Practice, whilst it is largely out of date in some areas, does give some guidance in respect to taking someone to hospital. So chapter 2 talks about transporting a person who lacks capacity from their home or other location to a hospital or care home, saying it won't usually amount to deprivation of liberty. For example, taking them to hospital by ambulance in emergency, even where there's an expectation that the person might go on to be deprived of the liberty once they get to the hospital, or for the purpose of the Code of Practice talks about care homes as well. So it's suggesting that the journey itself is unlikely to constitute a deprivation of liberty, so that the authorisation would be needed before that commences. And then it talks about being very few exceptional circumstances where taking someone to hospital amounts to a deprivation of liberty. And it sort of talks about where it's necessary to do more than persuade or restrain the person for the purposes of transportation, or where the journey is exceptionally long. And it's only in those cases you should look to the Court of Protection to look at a lawful basis for that. So the Law Society also issued some guidance around when to apply to the court for transportation in respect of hospital admission. And they suggested factors that might be relevant are whether you would need to arrange for assistance of the police or the statutory services to actually force entry into the person's home and assist in the removal of the person. So that's about an individual where you can't even gain access to the home. Now, it's not that the court can necessarily authorise that access, but it's just, I think, an indication of the level of objection. And then following on from that, again, indicating that where it's necessary to do more than persuade or provide that transient forcible physical restraint during the transportation. So if you're talking about really significant restraint in secure transport, maybe 4 or 5 to 1 support, and for quite a long journey, those are typical cases that might push over into deprivation of liberty, particularly where the person might need to be sedated. So they're all the relevant guidance that exists in addition to this guidance that's been published. So that is the end of my session. So I'll hand back over to Joanna, and I think she's picked out some questions that we can go through in the Q&A.
Thanks, Rachel. Thanks, Ellie. Yeah, I've been monitoring the chat, and obviously you've seen that responded to some of the questions as we've gone along. I can see that I've opened a can of worms about the use of deprivation of liberty safeguards in A&E. So what I'll do is I'll confirm that outside following today and include confirmation in the chat, because there's lots of people that didn't agree with one of my responses in the chat, so we'll follow that up. But otherwise, I just pulled out some questions that I thought would be useful for us to discuss now. So the first question that I selected related to Rachel's talk first about Section 21A applications. Rachel Kelly's had to drop off to go to court, so I'll pick this one up. And the question was, what is the managing authority's responsibility? So the managing authority is either the hospital or the care home for managing objections. Is it the responsibility of the managing authority or the supervisory body to take the case to court? Provided the managing authority has notified the supervisory body of the objections, have they met their requirements? So I think a good way of answering this is case law. Now, unfortunately, I can't remember the name of the case because they're all initials. Rachel, you might be able to jog my memory. But one of the first cases that identified that if the person is objecting to the deprivation of liberty, then a Section 21A application needs to be brought on their behalf. And it was the case of the lady, and it was her nephew had been he'd been selected to be her relevant person's representative, but he wasn't bringing the application on her behalf because even though she was objecting, he felt that she was in the right place. And in that case, it was the local authority that was criticised ultimately when the case was brought to Court of Protection for not bringing the Section 21A proceedings or not making an application to court. So essentially agree with the premise of the question there, that the managing authority or the care home needs to pass on those objections and make sure both the relevant person's representative and the supervisory body and potentially the commissioner, if that's a different public body, are aware of those. But I wouldn't suggest that it was the managing authority's responsibility to bring the case. It's first the relevant person's representative, but then if they're not doing their job, it was the local authority that was criticised in the other case, but they were both supervisory body and commissioner in that case. So hopefully that answers that question. And then we had a few questions that sort of arose because of resource implications, and this is a common theme throughout all of our webinars, that the various frameworks are set out to work when there's enough resources for the assessments to take place as they're expected, and where we get challenges is that there's not enough resource to sort of make the frameworks work in practice. So one of the questions was about if a patient is in hospital but the local authority is yet to visit to complete the assessments to do a Section 21A, to do a standard DoLS authorisation, can a Section 21A application be brought on the person's behalf? And you do need a live, either urgent or standard authorisation to be in place to sort of for the hook for the Section 21A proceedings, because your Section 21A proceedings is a challenge against the standard authorisation. So if the person's objecting and it's felt that the Court of Protection needs to be seized of this, then either the local authority needs to be contacted and prioritised to put that authorisation in place, or if this is a person in hospital, then the trust may need to consider, if the objection is so strong, making a welfare application at that point. And you'll have seen me mention in the chat that proceedings can subsequently be reconstituted as Section 21A proceedings, but it might be that welfare proceedings need to be brought initially. And Rachel, have you got anything to add to either of those points?
Oh, no, sorry, I was trying to respond to another question. Sorry about that.
Right, okay, no, not to worry.
No, I agree with what you said. I haven't got anything else to add.
Okay, thank you. Okay, I'm just going to go to Ellie next. There was a question about your case that you talked about regarding Mr. Gardiner. and there was a challenge, I think, to a living will and the validity of that. And the question was, what evidence was required to ensure that this was valid?
Yeah, so I think the judge in the case said he had 3 questions to answer. So, was the advanced decision to refuse treatment a genuine document made of Mr. Gardner's own free will? Is it valid? And does it apply to the current or future treatment? In terms of the evidence, the judge looked at Mr. Gardner's history and his the recent history, including when he made the living will, and following that when he was admitted to hospital and his time in hospital. Mr. Gardner's family submitted quite a bit of evidence and sought to rely on handwriting experts and linguistics experts as well. However, Mr. Gardner, he had made a lasting will and testament, a living will, and he'd also written a letter to the judge to explain his decisions set out in both of those. So there was quite a lot of witness evidence and views of family, views of his fiancée, and views that were gained from his previous wishes and feelings. So after reviewing all that and the medical evidence and looking at the document itself, that's how he concluded that it was valid and applicable.
Okay, thanks very much. I think it was the other case you mentioned as well. Is it YD with the man with the 2 partners? In both of those cases, I think he discussed sort of end of life and things like that with his partners, both of them, in his life.
Yeah.
And that it helped the judge, didn't it, to make that decision?
Yeah.
So I think, for a takeaway for all of us, really, not necessarily as professionals, but just as people, is to have those conversations now so that people know about your wishes and feelings. Thanks, Ellie. Rachel, I don't know if you spotted, and this might have been the one that you were answering. There was a question essentially saying if significant restriction and restraint was needed such that it was considered a deprivation of liberty that needs court authorization to bring someone into hospital, it's a non-emergency treatment, whose responsibility is it? Classic question. Whose responsibility is it to actually make that application?
Yeah, so a lot of the time, it's actually been the hospital who's made the application, because they want the person to come in to deliver a specific treatment to the individual. In practice, even though maybe they are the applicant, it's been joint working between the inpatient team and any sort of community provider that might be in place. So I've had different cases where the person's just at home and the parents are involved, or the person's got a care package and the care staff have been involved in the plan for the admission. Sometimes if it's quite a complex case, the commissioner of the community package will also be involved. And if it's a community request for admission, so the hospital doesn't know the person, the hospital isn't asking necessarily for the admission, sometimes it'll be the community commissioner along with the community team who will lead on the application and just ask the hospital for confirmation of things like where they would go on arrival. But a lot of the time it does take some joint working, and a lot of it will depend on the scenario. So I suppose really the easiest way to answer it is who's asking for the patient to come into hospital. They should lead coordination of that, or at least identify all of the individuals who need to be involved. We've had some cases where, as I say, commissioners have led on the application if it's quite complex, and as I say, in other cases where there is, say, a lead consultant involved and they want the person in so that they can do some investigations or provide some specific treatment to the individual, the hospital's then led on the application in that case.
Okay, Thanks. I think the sort of key message is really joint working, work together, because it's really doesn't reflect well on the organisations if everyone's arguing that someone else should make the application and no one wants to do it. So, you know, no hard or fast rule effectively, is it, Rachel? It depends, and there should be.
Yeah, I think
there should
just
be
needs to focus on, the person needs to come into hospital. How can we make it happen? Let's all work together to make that happen.
Absolutely. Thanks very much. Well, I think that's a really positive note to end on. And thank you, Rachel and Ellie, and other Rachel who's not here. We'll pass on our thanks to her. Thank you everyone for your attention and for your helpful questions. I hope that you found this morning's session useful, and no doubt our next session will be looking in more detail about deprivation of liberty, thinking about LPS, and if we can, feeding back from the case that's currently going through the Supreme Court. So please watch this space, because there's likely to be some really important developments over the coming months. Thanks very much, everyone. Goodbye.